Yes, madam. Any updation?
Yes, Your Lordship, I have received the case diary
Huh?
and I have submitted it. But however, Your Lordship, in the case diary which I have received, the grounds of arrest is not annexed, it's not attached. But I checked from the phone and it is similar with the one the appellant has annexed in his application. The FIR is there along with the production before the CJM. And the one which I have left, Your Lordship, that is the order, that is the date when the three accused, there were three accused actually in this present case. The three accused were produced before the CJM court. That is on the next day after the arrest. They were produced before the CJM on 31st.
The trial court also, the remand magistrate did not record. Have you seen the order?
Yes,
It says this court is satisfied with the mandatory provision in respect of
arrest.
BNSS duly followed. Grounds of arrest under section 47 is complied by communicating the accused in writing and explained in a language he or she understands. There is nothing regarding 48.
Here, arrest intimation is also given to the appropriate person. It is written.
Where?
Next. It is
No, but he
written.
has written down for 3, we do not know.
Yes,
three.
Your Lordship, in that regard, my submission is still the same. Even though in the last hearing, the counsel submitted that there is some confliction between Mihir Rajesh as well as this Poonam Raghuvanshi. But however, there is no confliction at all. The judgment is still stands. It's same, except that in Poonam Raghuvanshi, there is a differentiation between service compliance. The difference is there, only that part. Even in Poonam Raghuvanshi, it still stands that where there is non-compliance, arrest is vitiated. But however, in the new citation which I have cited, Poonam Raghuvanshi, even here it states that if there is non-compliance, the arrest is completely vitiated. But however, there is a differentiation between non-furnishing, non-service and non-furnishing of adequate reason. So in that case,
Where is that?
in para number 11, para 11, we find that the respondent is not entitled for bail both on merits and on the grounds discussed by both the courts. There is a fundamental difference between non-service of grounds of arrest and non-furnishing of adequate reason thereafter. While the first category might vitiate the arrest, in the second category, one has to see the prejudice caused to the accused. So the burden is on the accused to show what prejudice have been caused.
So you are trying to say that when he has written down on that particular document
Yes,
that these are the reasons for my arrest,
yes.
he was furnished the same, the notice may have been
Notice is
wrong
also,
in form or the wrong in noting down everything, but he was furnished the grounds of arrest, he knew them.
no,
That
Your
is what you
Lordship,
want to say.
the grounds which the learned counsel has placed is that in the arrest memo, grounds of arrest, I'm sorry, in the grounds of arrest, only the section is written.
He is saying that it is written by the accused.
He said that is confessional. But
We are not taking it to be a confession. Let us say it is not a confession. It cannot be used as a confession because made before the police everything goes. But that is a matter for trial. We will not decide it now.
yes,
What he is trying to say is the notice has to come from the police
yes,
and the grounds of arrest is written by the accused person.
yes,
So this is not a notice from the police to the accused person.
yes,
It is something that the accused has been made to write down.
actually the why he was written like that is that because he is written down in his non-language actually. The
So
police
that-
the police
that-
the
no,
police
that has to
person
be-
cannot write.
No, that part which the accused has to write that I have understood this is the ground. That has to be not in the grounds of arrest. That has to be filled up by the police.
Yes,
He has to write down below somewhere that yes, I have understood everything. Can he write the application itself? It is like saying you are going for a passport and the passport officer is filling everything for you.
and
Cannot be.
here and now the council is submitting the translation which he translate by himself.
Which one?
The translation.
No, luckily or unluckily, I can understand Assamese.
Yes.
So
So
I think the translation is correct.
now I cannot read this one actually.
No, I'll tell you. It has written. What it is written is this. I'm not looking at I'm looking at page 16. Okay.
Page 19.
Page 19 you want to read. Okay.
Page 19 is the
Okay, very well. Page 19 is one of them. Now you look at page 20.
okay 20.
Okay.
Yes.
I will translate without looking at page 20. I will try to translate page 19 from Assamese. It says that according to the case written above, since drugs have been found in our vehicle, the police has arrested us and the cause of arrest or grounds of arrest has been explained to me in Assamese.
Yes.
Roughly that is the translation. It may vary in language. Found in a vehicle and they explained our vehicle.
Yes, Your Lordship.
Without looking at that, I have translated myself. It remains the same. So now if we look at page 19, detailed ground for such arrest has been written by the accused. Is it acceptable in law that he will write his own ground of arrest?
That in that regard, Your Lordship, I don't know whether I will convince the court or not, but my objection will be there is no prescribed format
Yes.
which has to be followed. And the only purpose for serving grounds of arrest is to make him aware. And in my understanding that what prejudice has been caused to him has to be explained by the accused. By writing down this one, that in my vehicle so and so, what prejudice has been caused to him, that has to be explained. And that is the rigor of the new citation which I have produced, and that was was decided on 23rd July this month, that last month. That Poonam Raghuvanshi.
This order of this High Court, bail application 59, where the court said that this is a bizarre thing, making him write
Yes,
on the ground
Your
of
Lordship,
arrest.
in that regard, another thing which I would like to point out is that at that time, in the last order which the Learned Council has mentioned, that time this new judgment has not come yet, because only Mihir Rajesh was there. And now Poonam Raghuvanshi has come out, differentiating the condition of the arrest. Because during Mihir Rajesh, there is no differentiation at all. Only the thing which is written is arrest is vitiated. Only that part is written. And now with this Poonam Raghuvanshi, the new condition has come up. And that is on 23rd July, last month. And all the citation which we have placed, that is the judgment with the coordinate bench so and so, all are before the Poonam Raghuvanshi judgment. At that time, only Mihir Rajesh ruled.
My Lord, may I just submit for 60 seconds? My Lord, I think, my Lord, I will not argue on 47, 40. We are missing a very vital point here. Yesterday night, my Lord, while I was contemplating on this case, I formulated 3 questions and I could lay hands on a 5-judge bench judgment, one time. Question number 1. Can a division bench overrule the order of another division bench which was prior in point of time? For example, a judgment rendered on 1st of January by 2-judge bench, can it be overruled by a judgment rendered on 1st of March by a two judge bench? The answer is no. Correct course is either refer it to a larger bench or follow the earlier two judge bench. Now, my lord, here, it will kindly give that small noting I made, that on 47 and 48, both kindly give that small noting which I have made.
The recovery here is of commercial quantity, yes?
Commercial quantity. Now, my lord, your lordship is holding which one first, 48 one or 47 one?
I don't know. 48 is what is here.
Okay. Now, my lord, I'm sorry, I should not use 48. Now, 48, my lord is there at that 48 one. My lord, at 48, I have just taken those, my lord, which ignore all other single bench orders, my lord. I'll just rely on Supreme Court and Division Bench of our High Court. Kindly see number 1, Mihiraj, what it says, para 42. The grounds of arrest must be furnished in writing in order to attain the true intent. Vihan Kumar, is writing is not only to the arrested person but also to the friends, relatives or such other person as may be disclosed or nominated. What does Division Bench says? Division Bench of our High Court says, thus keeping in view the decision of Supreme Court in Vihan Kumar, we are of the view that the grounds of arrest in writing would have to be made known not only to the arrested person but also to the family member or relative of the arrested person.
Okay.
My lord, rest are all single bench judgment. I need not travel. These are Supreme Court and Division. Now, my lord, we finally take up this Division Bench judgment para, this judgment, order dated 21/8/2025. Kindly, it is there in the letter. And this Division Bench judgment was put to challenge in Supreme Court. Supreme Court dismissed it in limine. This Division Bench, 21/8/25. Then give me this. Where is that? Where I made some notings, no?
Criminal appeal 234.
Division Bench. The lordship is there. Now, my lord, will kindly come. My lord, I'll just take, my lord, 30 seconds before this, before your lordship comes to this, before I get. What happened in this case is that a similar situation, there was a judgment passed by a two-judge bench of the Honorable Supreme Court where they introduced this prejudice test. That violation will per se not make it arrest illegal, provided you show prejudice. Then what this Honorable Court, the division, so one single judge in the principal bench was of the view that the prejudice test will have to be followed. The other single judge was of the view that no.
Now, Mr. Biswas, if before we go further into this, one bail application has been rejected by the division bench of our court, saying that the prejudice test would apply. This order, this that we are reading, that order is prior to 21/8/2025. I'm sure of that.
My lord, the question here was a question of law. My lord, will kindly come to para 15 of this division bench. What was the question referred here? In Darshan Kumar, the Supreme Court has para 15, the lordship will read and I will not make any submission.
And that we have read. So now, our division bench judgment, if it is prior in time saying that the test of prejudice has to be applied, this would not help you.
Now, my lord, here, this is just as an academic discussion I have referred to this. In the present case, there is total non-compliance of 40. Total, absolute. Not even. And as far as this new law is concerned, my lord, since we have a little bit of time today, so I am saying this new judgment, my lord, kindly appreciate two things. The new judgment says, ground of arrest has to be furnished. It may not be adequate. If somebody argues adequateness, so quickly. Now, my lord, what is ground of arrest? Ground of arrest is defined under this, the write-up which I have given for 47, kindly take up.
Now, let's see.
Yeah. So that defines the grounds of arrest. Para 48 Mihiraj. Can Mihiraj be overturned by Raghuvanshi? Say equal.
What we are simply to see is there was a 47 notice. In your vernacular language, the accused has written down there that these are the grounds of arrest which have been told to me. Our High Court single judge says this is bizarre. In case I differ, and I think that it is proof of service of grounds of arrests which has been acknowledged on the notice itself, I will have to differ with the learned single judge I will have to refer it for a. And if I think that yes, it is bizarre, I follow it, I grant the bill.
But on 48,
On 48, the phone number could not have been imagined by the police authorities. It was a number which you had supplied. That is what the law requires. It is someone whom you nominate has to be informed. Number is your wife's. There is something in the police record to say that it was given. Now, whether that giving, if taken to be true, suffices. What more to see?
that is the question which is what we have lordship has followed. That is precisely what I am trying to answer. My answer to the question number 2 is that, my lord, all this compilation of 48 which I have made, my lord, right from Mihir Raj to Bihan Kumar to the division bench and to all other learned single benches, I am not even going to the single bench. They say clearly that Bihan Kumar cannot be, my lord, tickled with by a 2-judge bench.
Anybody and every, all said and done, the only issue is there are practical difficulties which are coming up and in which bail is being granted or bail is being granted on a certain understanding. A man sitting in Jammu and Kashmir, see the paradox, man sitting in Jammu and Kashmir, wife at the relative whose number he gives is sitting in Jammu and Kashmir, does not have a phone number, sitting somewhere in the hilltop without a network. Man knowingly commits a crime at Tamil Nadu, maybe Kerala, maybe Madras, wherever, down below. And the police is now required to serve a notice upon the in writing before production before the remand magistrate. 24 hours you cannot cross, the arrest is vitiated. How to do it?
The answer is,
Tell us.
the answer is there. It is, this has also been taken care.
Tell us.
Then the law says that reasonable time, that darshan judgment is of that. It says it may not be possible. Somebody is in Delhi, the family member is in, say for example, Nagaland. Then you send it through post to the nearest police station and ask the nearest police station, you send 2 notices. One to the address, because once you have a phone number, you also have an address, and send it to the nearest police station with it. Now, in that case, if there is a delay,
Would either suffice?
either suffice. In that case, if there is a delay, that will be acceptable. That's what the law laid down. I can identify the specific
Now,
paragraph.
once the phone number, if only a phone number is supplied without an address, what happens?
His address is there, my lord.
Whose
Now,
address?
now, his residential address. Here, my client's residential address are there.
In the 47, 48.
My lord will see. Even in the,
It is there, 16. Yes, it is there.
my address is there. You don't choose to. My lord, why the Supreme Court is time and again saying that it has to be in writing? Because in order to, my lord, because the principle is that let 100 guilty men be convicted, let not one innocent man be acquitted, let not one innocent man be convicted. These are the golden principles. So, my lord, so that there is no police, tomorrow, so that, a man is not victimized by any agency. So, therefore, these protections are given. Now, time and again, the Supreme Court has said, because it can be easily manipulated. I give a phone number. Maybe what I have spoken, can it be documented?
She is estimation these people are Mizo. We will not say.
Your Lordship, in that regard, if we look into section 48, this is acknowledged by the village council president that they have called the wife. Even the village council president has acknowledged it.
No. According to Mr. Biswas, every person except the accused is against him. Everybody has lied. So we are going by that. No problem.
I am not saying, I am only to maintain the sanctity of what I am submitting, what I have read. Not a single word, my lord, I am making of my own. Mihir Rakesh says in writing, Bihan Kumar says in writing, division bench says in writing. Division bench says delayed compliance is okay. Our division bench says that 18 days delay was unreasonable. Maybe 10 days delay. Your lordship is right. Because 24 hours, within 24 hours, he'll have to be produced. But total non-compliance. You don't care what the Supreme Court says. Tomorrow you will not care what the High Court says.
Okay. Disposed of. You'll have the order tomorrow. We have got a meeting today. We'll try to have it by the afternoon if possible. There's one meeting at around, we'll have to start now. It will take us around 1 hour or so.
Why not wait before, because since you know, that compilation which I have made regarding 47 and 48, and that question that if the subsequent judgment does not take into account the former judgment, what the subsequent judgment of the equivalent bench will be termed as? It will be termed as par interior. To that effect, I'm just that one 5-judge bench judgment, I'll write the para number in the top. I'll just write the
Your
para
Lordship,
number on the top.
Your Lordship, in that regard, as I already mentioned, there is no conflict at all. The council is misunderstanding the Mihir Raja's rule that
that
if
is
there
why-
is non-compliance, it will vitiate the whole arrest. Since Poonam Raghuvanshi also stated the same, except that there is a differentiation between non-service and
As far as Poonam Raghuvanshi,
Just a minute, Mr. Biswas. What happens is this. Two councils will never be able to convince each other.
that's why.
Therefore, I sit here to see if we can convince one of
But
you by an
Your
order.
Lordship, what I mean to make this court understand is that because the council is trying to mislead, saying that there is some confliction in that judgment, but there is no confliction at all. It is not conflicted at all. The stand is still similar.
We'll take care of your submissions. We'll
And
take care
Your
of this
Lordship, another point, what the learned counsel has said day before yesterday, he mentioned that even in the different bench, in Aizawl bench, this kind of bail has already been decided. And in that regard, what I would like to mention here is that, Your Lordship, all the bail application has to be considered differently as per the materials on record. And as I have already mentioned that the citation which I have produced, that Raghuvanshi, that is decided only on 23rd July. At the time of hearing, this citation is not there. It's not there to produce at all. So the stand made by the council cannot stand at all. Saying that we have already accept all these bail applications. I just want to.
I was maintaining a very sober, my lord. Since she has used the word misled.
That is your beauty, Mr. Biswas.
Since she has
You keep your cool all the time.
since she has used the word misled, then my lord, I must say,
No,
with all humility, either the choice of word was wrong, or my lord, Raghuvanshi has not been understood at all. Raghuvanshi was on the, because that a bizarre argument was made before the Supreme Court saying that in the first, there was some wrong section. That's what everywhere. My lord, then the 5-judge bench judgment which says that one word here and there can lead to a lot of a difference in the completion of a. Raghuvanshi does not dispense with the requirement of sending notice in writing. Raghuvanshi does not speak of dispensing the requirement of reasons of the arrest. It says adequate. For somebody, 1 page can be adequate. For somebody, 5 pages may be adequate. Not required. Here is a case. Give the basic detail. 21. My lord. With all humility, I am saying, there will be very less people even in the bar will straight away can say what is at section 21C. It is only today while I was trying to High Court, I tried to check with the evidence. 21C, and they expect a layman to understand 21C. Commercial quantity of what? Does it speak of ganja? No. Does it speak of psychotropic substance? No. But we expect a man to understand, to accept 21C, that section there is nothing. And Supreme Court has clearly said that quoting of sections and all these things will not make ground of it.
We are not even going into those arguments. This is a bail petition. We are deciding something big, huge. What we are required to decide is whether on what has been given to you, does it constitute appropriate 47 and 48 notices or not? And that suffices. If it suffices 47 and 48, done. If it does not suffice, a smile back home. We'll just try to find out whether writing on that particular piece of paper by the person in a language that he understood is bizarre. And do we differ with that or do we agree with that? And the other part is that when there was a phone number and the allegation is that they have spoken to each other, they've understood everything, does it end there?
The burden is on the prosecution to prove.
True.
That law is also there. The burden is on the prosecution to prove.
It is on the prosecution.
My lord, mentioned memo I am supplying, my lord, your lordship's bench. What happened, my lord, this matter came up yesterday. Your lordship has felt that counsel has fallen sick, my lord. I am just mentioning, my lord, because there is a system in IOL bench. We cannot file additional affidavit without the permission of the court. So I am just mentioning it for listing tomorrow so that I can take the permission for filing an additional affidavit, not for arguing the case.
Allow that, for tomorrow. Thank you.